Speaking of Capitol Hill, today we're talking about Qanon Shaman. We're having to go back to January 6th and revisit this case. And as I said at the start of the show, not a fan of this individual, right? This guy did something I think was totally inappropriate. That being said, he deserves due process. He deserves a presumption of innocence. He deserves a fair shake throughout the proceedings in a court of law, and he is not getting that, not at all. And it's reprehensible, actually. We're going to go through an opinion from the judge that I think is grotesque. We're going to get there in a minute. Let's get some background. This comes over from the Post-Millennial. Here is the Qanon Shaman over here. You can see what a dangerous individual this is. I want to draw your attention to this little spike here because this spike scared the judge, doesn't like it, says it's very dangerous. And apparently, if you have this spike, it's sort of like the ring from the Lord of the Rings. If you have this spike, apparently you have magical powers where you can seize control of the United States government, apparently. Now, he wasn't able to do it on January 6th, but apparently he sort of leveled up his powers. You can see here this vein popping out of his neck. So he is sort of turning into a insurrection maniac, and he's got this spike that he's going to go seize the government. A prominent figure in the January 6th riot, the Qanon Shaman, Jacob Chansley, going to remain behind bars, cannot be placed on house arrest. This judge, Royce Lamberth, made the decision believing that Chansley would otherwise have an opportunity to plot further anti-government attacks, and he's a possible flight risk, even though there's no evidence of either one of those things. The decision came after a purported attack on D.C. was predicted to happen on March 4th, but never came to fruition because it wasn't ever a thing. Court documents reveal a debate among the defense and the prosecution about how dangerous Chansley actually is. Much of the deliberation centered around a 6-foot spear he held during the riot while present inside the Capitol. The judge strongly disagreed with the counter-argument that it was just a flagpole. In the document, the 6-foot pole with a metal spearhead on top was compared to a knife in terms of its danger. The judge says here, quote, "Both objects have a sharpened point designed to harm by piercing or puncturing." Okay. Prosecution concluded that because the defendant's 6-foot spear is inherently dangerous, it does not matter whether the defendant actually used it to cause bodily harm while inside the Capitol. So basically anything that is dangerous now is a weapon. The court found the defense's argument trying to justify his release inadequate. Lawyers brought up the fact that he lived in Arizona, shout out, his entire life, and that he doesn't have a passport. In addition, the defense leaned heavily on his mother, the fact that the defendant lives with his mother, and that his mother told 60 Minutes that he walked through open doors and escorted into the Senate appeared uncompelling to the court. So he's doing I was just part of the tour defense. It was already open. Chansley's defense team argued that the fact that he published 2 self-help books was enough proof that he's a man of shamanic faith with no interest in politics. All right, so let me give you some background on this. The law states, generally speaking, in Arizona and federal law, that we want to give people the presumption that they can get out of custody. We want people out of custody, just as a matter of policy. Somebody gets charged with a crime, as long as they're safe to the community, as long as they're not a danger to anybody or themselves, as long as they're not a flight risk, we want people to be out. Because the purpose of the justice system is supposed to be about rehabilitation. It's about behavioral correction. It's not in practice. It's really very punitive, as we're seeing here. It's mostly punitive, but it should be. And people like to talk about this in fluffy terms and say, well, we're going to release people. We want it to be rehabilitative. I don't buy that, but in theory, it's supposed to work that way. And so when people get arrested, we want them to get back out of custody so they can get back to school, get back to their families, not lose their jobs. Even if you keep somebody in custody for 48 hours, that's going to wreck a lot of what they have coming in their future. So we want people to get back out. The laws, the rules are all set up to help that. This guy, judge said should not be let out of custody. All right, let's break it down. Let me show you why. This is from the court opinion. After the defendant, so you can see here, this is filed in the district court. After the defendant was arrested on charges stemming from the January 6th riot, he now asked this court to vacate the order of detention and release him as he awaits trial, which could be a very long time. Court held a hearing. They said the court will deny the defendant's motion to revoke the order of detention. The court finds that no condition or combination of conditions of release will reasonably assure the defendant's appearance as required or the safety of others and the community. So they're saying 2 things. One, if we let this guy out, he's not coming back to court. And if we let this guy back out, he's going to do this again. He's going to injure somebody else, right? Now, look, in my opinion, this guy was just somebody who was a knucklehead, honestly, right? What he did was inappropriate. I don't endorse it. I don't condone it. But did he injure anybody? No, not to my knowledge. Did he seize control of the government? No, not to my knowledge. Did he enter into the Senate building in a very sacred place and disrupt a formal government proceeding? Yeah, he did do that, along with many, many other people. And he was eventually escorted out of the building. And that was it. They were back in session in like 4 hours. Okay, not a criminal mastermind, not somebody who shot and murdered somebody. Okay, let's think about this. Many other people throughout this country get bonds. Kyle Rittenhouse got a $2 million bond. Crystal Kaiser got a $1 million bond. Those bonds both resulted in dead people, regardless of what you want to think about those cases. Even Brittany Gosney, who murdered her 6-year-old and threw his body over a river in Ohio, got a $1 million bond, okay? So if she can come up with the money, she can post it and get out. Derek Chauvin was out on bond. He allegedly murdered a man. He got a bond. This guy, no bond. Why is that? Could it be political? Let's take a look. Here it is, the procedural history. So these are the different charges that he's facing. We have obstructing an official proceeding. So that's it. We've got, those are both felonies. We've got disorderly and disruptive conduct in a restricted building, violent entry and disorderly conduct in a Capitol building. We've got parading, demonstrating, picketing in a Capitol building. No murder charges, no dead people. So maybe he should be released because Kyle Rittenhouse is released and there are three people who were killed there. So this is Kenosha, where a judge reviewed the case and said he's free to go, as he should be. In this case, we have a DC judge not going to let out the QAnon shaman because he had a spike and because he did some drugs. Let's take a look at this. Now, the defendant is asking to be released. He says that Judge Fine ordered him detained. He said there are significant developments which justify the new motion. Those developments, he argued, include the fact that President Biden was inaugurated. COVID-19 pandemic has made it difficult for the counsel, his defense counsel, and him to have unmonitored communication. He said that he wants to be temporarily released for compelling reasons. Currently, his faith precludes him from receiving a COVID-19 vaccination. And the pandemic has made it impossible for the defense and the defendant to speak privately. So a lot of these are the same arguments that you hear. We saw a lot of these arguments in Ghislaine Maxwell's case. Traditionally, these are not justifications for getting out of custody because you and your defense attorney can't communicate well. Well, the judge is going to say, well, figure it out, right? Come down to the jails, set up virtual proceedings. Most jails have mechanisms that help facilitate that. And in this case, they're basically making the very basic rudimentary claims that you would make because he should be out of custody. Let's take a look here. It says the Bail Act, Reform Act authorizes the defendant's pre-trial detention. The government argues the defendant is subject to pre-trial detention because he carried, why keep him? Because he carried a dangerous weapon, a 6-foot spear during the commission of the crimes charged. So he carried a dangerous weapon. So the government is asking that he does not get out of custody. In response, he said he did not carry a dangerous weapon into the Capitol. It was not a 6-foot spear. It was a flagpole with a spear finial. The spear finial, he notes, is the traditional Native American design. All right, so that sounds reasonable to me. Under this definition, the court finds that the 6-foot pole with a metal spearhead fixed to the top is undoubtedly a dangerous weapon. Like a knife, it is inherently dangerous. Both objects have a sharpened point designed to inflict harm by piercing or puncturing. Moreover, a spear can inflict those puncturing and stabbing wounds at a distance, making it even more effective as an offensive weapon than a knife. Thus, because the defendant's 6-foot spear is inherently dangerous, it does not matter whether the defendant actually used it to cause bodily harm. All right, so, okay. Okay, Judge. This is another paragraph. Now, let's take a look at the history. So, first and foremost, they're defining that as a weapon that justifies not letting somebody out of custody because he had a spear. Okay. Kyle Rittenhouse had a semi-automatic weapon. He's out. Crystal Kaiser killed somebody with a gun, burnt down his building. He's done, or she's out. Derek Chauvin put his knee on George Floyd's neck. He was out. This guy was holding a wooden spear. Didn't even use it, but was in the Capitol building and was part of the MAGA movement. Okay. He has to stay in custody. Is that fair? Let's go look at the defendant's criminal record now. Next, the defendant's history. So the judge will look at this stuff, right? How many times have you been arrested? How many times have you been charged with a similar crime? How many other criminal convictions do you have? How many times did you not show up to court? Let's take a look. The defendant's history and characteristics further indicate that no condition or combination of conditions would reasonably assure the safety of any other person and the community. All right, well, why is that? Though the defendant has no criminal history, the court finds, so that the court acknowledges no criminal history. The court finds his blatant disregard for the law on January 6th to be a telling indicator of how he would act if released. Not only did the defendant have the audacity to enter the U.S. Capitol during a joint session, disrupt the certification, and walk into the chamber, he did so without full knowledge that he was being captured on, with full knowledge that he was being captured on film. He asked, okay, all of that stuff. Furthermore, the defendant's history of drug use and his willingness to lie about that drug use, and yet more examples are of the defendant's willingness to openly break the law. All right, so he's not even commenting on whether marijuana is legal in the state. He's not commenting on whether he was using psychedelics or psilocybin. Those are legal now in Oregon. So he's making a conscious decision now to choose federal law. He's a federal judge in the DC circuit, so he's entitled to do that. But he's writing an opinion here, picking the laws that he wants to make his point. Openly break the law. Well, not if he's in Oregon. Not if he's in Arizona now. You can smoke marijuana, no problem. It says here, pretrial services report said that from Arizona, he says he smokes marijuana 3 times per week. Well, we have medical marijuana here that was allowed back on January 6th, and now we have recreational marijuana, so it's not illegal here, openly breaking the federal law, which is not even enforced. Right? There aren't DEA agents sweeping into Arizona and pilfering all of the dispensaries that we have here. They're all operating normally, functionally. But this judge wants to say that is breaking the law. Okay. And though the defendant told pretrial services that he did not use any other drugs, he's openly stated on his podcast. So the judge or somebody from the court went on his friggin' podcast and said that he uses psychoactive substances and mushrooms as part of his shamanistic practice, which is a religious practice. And the court said that they had to accommodate his diet. I think it was a vegan something diet, based on his religious practices. So the court has already acknowledged that this is a legitimate religion. Why can't he use legal drugs in some states to support his religion? It's because this judge is trying to make a point. And he can do it. The defendant, thus, despite the defendant having no criminal record, the actions on January 6th were not the first time he broke federal law and publicly displayed his remorseless for having done so. I wonder if this judge has ever broken federal law. Do you think this judge ever has? Yes, I would say probably. Right? In many, many different ways. Has he ever broken local laws? Probably. I've made that comment on this channel. You break the law every day. You don't even know it. I could get into a car with any one of my friends and say, law, broken. Right? People do it all the time. Because our laws, our criminal codes, our statutes are like this thick. There are laws for everything. Everything is criminal now. I'm sure the judges too. Maybe the judge should impeach himself for breaking federal law for something. I'm sure we could find something. Nature and the seriousness of the danger posed to the community by the defendant's release. The nature and the seriousness of the danger posed by the release also weigh in favor of pretrial detention. The court cannot overstate, look at how dramatic this is. The court cannot overstate the gravity of the defendant's conduct on January 6th. Were the defendant released pending trial, he would have the opportunity to again attempt to disrupt the United States government or harm members of Congress. Moreover, the defendant's release would allow him to plan with others who might be willing to engage in these acts. So total speculation. Not even any evidence in this. Has there been any evidence? Did the pretrial report say that he was communicating with his comrades to overthrow another government, even though the first one was incredibly a failure? They were in there for 5 minutes before they were escorted out. This judge is just pulling reasons out of the air to keep him in custody, even though people are out of custody all around this country for crimes that are more serious than anything that happened here. Given the nature of this risk, the court finds that ordering the defendant to remain on home confinement would not sufficiently protect the public. Do you feel dangerous from Jacob Chansley? I don't. And although the court could also order the defendant is prohibited from communicating with others via telephone or the internet, the court is not persuaded that the defendant would comply with this condition. Why not? In supporting the finding, the court relies on the defendant's alleged refusal to follow directives from law enforcement officers once inside the Capitol building. His flagrant disrespect for law enforcement indicates he would not adhere to the conditions imposed by this court. So because he broke the law previously, I can predict as a judge that he's going to break the law again, even though he's being monitored, even though he could be a part of pretrial services. The judge could put him on an ankle bracelet. The judge could put him at home where he has to check in with a device that's installed into the wall that's connected to a hardwired phone line. The judge could make him check in, call a number, call pretrial service, call. There's a million different things that this judge could do. But instead, this judge is going back to January 6th, and because he did not like the conduct so badly, he's just going to make up other reasons to keep him in custody. For these reasons, the court finds by clear and convincing evidence that no condition or combination of release conditions could reasonably assure the safety of other persons and the community. What a joke. For the reasons explained above, the court will deny the defendant's motion for pretrial release written by this guy, Honorable Royce C. Lamberth, the United States District Court judge. Shame that that opinion is a part of a criminal case. And I am, as I said, not in favor of what he did. He made things a lot more difficult for a lot of people in this country. But this is BS. Now, let's compare and contrast this with what the U.S. Attorney's Office is doing in other parts of the country. So here, as I mentioned previously, we have a situation where there is somebody who seemed to be sympathetic to Trump or MAGA or whatever. I don't even know if that's justified. But let's just say that right now, the media, the country is, in my observation, they are saying that anybody who is a part of the Capitol Hill riots or the Capitol Hill protests, those are all Trump's people. Anybody who is a part of Antifa or BLM, those are the left's people. That's kind of the division that I've been seeing unfold around this country. Now, today, both of those political protests have happened. They happened in the Capitol building. They say they're going to happen again. They said they were going to happen on March 4th. That obviously didn't happen. So now they're bracing themselves for whatever the next wave is. I haven't heard of it or seen anything about it or even any murmurings about it. No, nobody's even talking about whatever that is. But we do know that now that there are some protests and some things percolating over there in Minneapolis and other parts of the country. Antifa has still been going at it in various parts of this country for some period of time. Both of those protests should be governed by the same law enforcement agency, by the FBI, if you want to go on a federal level, by the U.S. Attorney's Office. They're prosecuting crimes in both situations. The same U.S. Attorney's Office that reports to the Department of Justice, which is now being run by Joe Biden. They can make charging decisions about what to do. In this case, with Jacob Chansley, they had to want to keep him in custody. They are saying, we're going to keep him in custody. He's too dangerous. If the defense said we want to get him out of custody and the prosecutor said, well, we're not going to take a position on that. We have no opinion on it. Do whatever you want. Or they said, yeah, we're going to ask that he respond to somebody who's a part of pretrial services. We're going to ask that he have an ankle monitor. We're going to make him report home by 8 o'clock at night on curfew, whatever. But that's not what they said. They said, we want to keep him in custody. The U.S. Attorney's Office said this. Well, what are they doing in other cases? There's a great Twitter follow. It's called Antifa Watch 2. They have a nice summary here. Here's a dismissal from the U.S. Attorney's Office over in Oregon of Portland. Here are some Antifa rioters. So this one is Ezra Myers, failing to obey a lawful order, July 24th in Portland. Case dismissed. The United States respectfully requests motion to dismiss the information with prejudice. So this case is dismissed, right? Ezra K. Myers, also failing to obey a lawful order, very similar charges. U.S. Attorney's Office dismissed. It's the sixth dismissal since the inauguration. They've dismissed 23.9% of all 2020 Antifa rioting cases so far. This was posted on January 6th, just about over a month ago. Okay, here's another one. February 10th, this was posted. Here's two more dismissals. 25 cases overall. We got Essence Sylvester. We got Alexis Richter. Also failing to obey orders. Also disorderly conduct. Also on federal property, just like Jacob Chansley. From 10/7, Portland, ICE riot. Both completed a deferred prosecution agreement, which means they did some classes or they did some community service. From what we've seen, less than 40 hours of community service. So it's a slap on the wrist. I'm not saying that this isn't justified. I'm not saying that these people should not have their cases dismissed. I don't know the background of their case. I don't know what's involved. If they can do some community service and have a dismissal of the charges, great. So should the Capitol Hill people, by the way. The ones who, didn't plant pipe bombs. The ones who weren't bashing cops, with flagpoles. Those people shouldn't get a sort of a slap on the wrist. There should be something more substantive there. But these people got their cases dismissed out of the U.S. Attorney's Office, also for federal riots, also for rioting on federal property, also for disorderly conduct. Major double standards thus far. Let's go back. There's more. It's not just this one. Here's another one. Same from Portland, another Antifa. This one is Jerusalem Callahan. Over here, we've got willful damage to destroy property from a federal courthouse. These riot charges are dismissed. Billy Williams, who leads the U.S. Attorney's Office, resigns on February 28th. They're going to still track this on this thread. So this was posted on February 16th. Another dismissal. Government's motion to dismiss without prejudice. So it doesn't even look like that this person had to complete a diversion agreement. This just looks like an outright dismissal. Why? Because without prejudice means that this charge can come back. If you've done something in exchange for the dismissal, they'll dismiss it with prejudice, which means they cannot bring it back against you. So this just looks like a voluntary dismissal in the interest of justice. Dated February 16th. So their case is dismissed. Do you think that they were held in custody because they were dangerous? They willfully damaged and destroyed property in a federal courthouse. Kind of seems like the same level that Jacob Chansley's on. Who's next? Here's another one. We've got Nicholas Clober, 26, charged with entering federal property and failing to obey a lawful order. Again, July 23rd, federal courthouse. Also dismissed. Government's motion to dismiss with prejudice. In the interest of justice. Here's another one. Dismissed. Government's motion to dismiss with prejudice. Marnie Samantha Sager, previously Benjamin Samuel Sager, entering federal property, failing to obey a lawful order. Right? And Jacob Chansley still in custody. Other people who were not even in there on January 6th, not even a part of the Capitol Hill riots, as we've talked about, still in custody. Here's the last one. We've got another dismissal. This was posted February 21st, number 29 of 96. First one we've seen on a Sunday. Christine Lisa Margot. She was also charged with entering federal property, failing to obey a lawful order. Motion to dismiss. Okay? So massive double standard here. And totally inappropriate. Let's go over to the questions from locals.com over at our Watching the Watchers group over there. Head on over there if you want to join the great conversation. Here's Pinky2 says, do you think it's possible they are keeping some people in jail while this are in social unrest? I don't think so, Pinky. I think this is just purely political. I think that you have DC courts with DC judges who are extremely liberal, who all think that what happened at the Capitol building was like an analog of the Pearl Harbor bombing. Literally, I think Chuck Schumer said something like that. They're talking about 9/11 style commissions. And so I just think the political atmosphere in DC is still so hyperventilating about this entire deal that happened on January 6th that they are just totally out of touch. They're totally out of context, or they're just intentionally being punitive. The judges are being punitive because of the political disposition of the people who were involved. I can't come up with another reason. I mean, if you read that whole opinion, it's bad. This judge is twisting himself into a pretzel to try to come up with reasons that, in my opinion, are so speculative. There's nothing that's even based in fact about that, about what he's using as his elements that would justify keeping him in custody. Next question comes over from the doctor. Renal MD says, what about the presumption of innocence? The judge seems to say we are holding him for trial because he's guilty. You're exactly right. You're exactly right. The judge is presupposing his guilt. The judge has already convicted that guy. All right. So if this goes to a trial, he's got to make sure he's got a different judge, that judge is not anywhere near him. There's rules for noticing judges and things like that. Totally biased. Not even a modicum, not even pretending to be impartial here. Just going through, throwing out a bunch of facts on paper, or a bunch of opinions onto a piece of paper and calling that a political opinion. Nadarb says the shaman was actually one of the few that was trying to get people to leave towards the end while everyone was on the steps. There is no one I despise more than a crooked judge. Yeah, this judge, this is a reprehensible opinion in my opinion, in my humble opinion. All right, Rob, if you had a choice on being the defense lawyer for the Shaman, Kyle Rittenhouse, or Chauvin, and you could only pick one, who would you pick and why. So I would pick Kyle Rittenhouse for sure. Kyle Rittenhouse, I think, is a very important case for self-defense, for the concept of self-defense, for the concept of being able to secure your own life when being attacked. When I went through that analysis on Kyle Rittenhouse, we spent a lot of time talking about his case here. It looked about as clear as self-defense as I've ever seen. And I think that he is absolutely innocent of that. Now, you could have your argument about whether or not he was there or should have been there or should not have been there. But I think that as soon as the sort of the situation shifted bad, he was being chased. It was purely self-defense. And that is such a critical line in the sand that I would, if I had to pick one, I would throw all in on the Kyle Rittenhouse case. Good question. We have another one from JBone86. Says, Rob, should the defense counsel file a complaint on judges' politicization of the case against the Q shaman? So, yeah, I actually think so on this. So I know that's not a popular thing to say. You know, a lot of attorneys don't like to say that about judges. But judges are just like anybody else, right? You can file complaints against prosecutors. You can file complaints against any attorney. Go to the state bar, file a complaint. There are judicial boards. There are sort of judicial ethics commissions and groups that you can complain to. And I don't think attorneys do it enough, quite frankly. When you see a case like this, now listen, I don't practice in the DC circuit, obviously. I'm in Arizona. I'm 3,000 miles away. So I don't know what the context there is. Right? I don't know if this is just standard operating procedure. If you're charged with a federal crime in DC, does anybody get out? I don't know. I really can't speak to that. If that is true, if this is sort of the common practice out of this jurisdiction, well, maybe I'm barking up the wrong tree. Maybe this is just something that's pretty common. But I can just go around the different cases that we've covered. Everybody's out of custody if they can afford it. So the judge could have said, well, that's $1 million bond. If he can post the bond, then he gets out of custody. Why do other people get that benefit, but he does not? Why were all of those Antifa people, why were their cases dismissed? Very contemporaneously to what we're talking about right now, because Jacob Chansley's motion is also relatively new. So we're talking about the U.S. Attorney's Office is currently making decisions, some about Antifa and those protesters, some about Capitol Hill and those protesters, and they seem to be at different levels. One is very intense, very high bar, very dangerous. We're not going to let you out. Over here, we've got buckets of people who are throwing Molotov cocktails at federal court buildings. Jacob Chansley was holding a flagpole from a Native American tradition that has a spear at the tip of it that he didn't even use. And he's a danger. And because he mentioned that he does or tried mushrooms somewhere as part of his religion, that is evidence of him breaking the law. It's bad. It's a bad opinion. And I think that if you were practicing in DC, you probably have experience with this judge. You probably know him. You probably have some opinions on him as well. All right. So we got Norovira in the house says, are there any options for us as a society to act to remove bad judges? This is an issue with your next topic, hashtag Free Britney as well. Yeah, so it depends on the different states. You know, some different states have the ability to recall judges. You can impeach judges at a federal level. You got to impeach the judge. So that judge there would have to go through the impeachment proceedings, the impeachment process in order to remove him. Now you could do some things like if that judge got sanctioned or got disciplined by the Supreme Court or by the Circuit Court or by the federal bar, whatever, then that might cause him to want to resign or step down or just relinquish his practice. But yeah, no, it's a tough thing to do. In some states, judges are just like elected officials. They just run for office. Whoever gets the most votes wins. So in those situations, if you're talking about a state or local level judge, then you could just, run for office, run against them or support a candidate who is opposed to that judge. But the judges are very powerful in this country, as you can see, right? This is one judge who's really having a negative impact, I think, on Jacob and many other defendants. It's not just him, many other people. And I'd be very curious. I'd be very, very curious to see if this judge has differing opinions or what his history looks like as it relates to release condition motions. So if you went through and you said, okay, judge, we're going to look at all of your motions to modify release conditions, all of your detention orders for the last 10 years. Let's say the last 6 months. Let's say last 1 year. Is there a pattern there? Is this the same across the board? Or is he singling out certain people and trying to make convoluted legal arguments about spears and recreational drugs that were not even used in this particular case?